Hi, this is Professor McLaughlin with a lecture on Chapter 4 in the Hames Legal Research, Analysis, and Writing textbook. Chapter 4 introduces you to a very classical legal document called the case brief, and it introduces you to, and you may have encountered IRAC or that structured paradigm for legal analysis previously in some of your other paralegal classes, but it also introduces you to a basic structure that legal professionals use to organize arguments, to organize the opinion portion of a case, to organize analysis. And it's IRAC, issue, rule, application or analysis, and case. And what I want you to see it as is a flexible framework that you can add to, take away from, and use in order to achieve what you need to with case brief, but also with other legal documents. And that may become more clear when we get into the chapter on legal memos and writing an appellate brief or a brief to the court. The best way to understand and practice IRAC is to also read a lot of cases. So what I like about this book is it does force you to read cases. That's why I assign the appendices and have you read cases. And when you read those cases, what I'd like you to do is begin to identify that where the document or the case or the memo that you're reading has stated the issue. Then does it subsequently state the rule? Then does it begin an analysis comparing facts and applying them to rules and either neutrally or predictively, such as a legal memo, which is neutral in its tone, or stating an argument argumentatively, not like fighting, but supporting one side only and diminishing the power of the other side's argument. And then does it conclude? So this chapter walks you through the opinion and begins to help you identify the components of a case brief, which is much more than IRAC. But I want you to see IRAC in all of that. So the case brief is very structured, and legal writing is very structured. It has an order. It has components. And as you read Chapter 4 and read the cases in Chapter 4 and look at the sample brief in Chapter 4, hopefully you'll see this as, it is a little tedious, I'll admit it, but it's something you need to get down and something that will really help you as you read cases in the future. As you begin to try and understand what the issue is in a particular anything, or you want to state what the issue is. Okay, so let's begin with these slides for Chapter 4. Hold on. So components of a case brief. And I wonder if it would help. So if you're following along in the book, you can look on page 88 in Chapter 4, the Gideon v. Wainwright. If you want to take a look at that while I lecture on this slide, that might be helpful. So case briefs first identify the case, the name, and the complete citation. Then it discusses the judicial history. Typically with a case brief, you're looking at an appellate court decision or a Supreme Court decision, so there's judicial history. Judicial history is, where did it start? What trial court or district court did this case start in? And what was the holding there? And the reason we want to know the holding there is it was appealed. So who lost and who won? And for our case briefs, we're going to be very neutral in our tone, not trying to make an argument. We're trying to assemble the facts in a document that you could give to somebody else who never read the case or doesn't have time to read the case. And it would explain to them what it was about, what the judicial history was of Gideon v. Wainwright. So procedural or judicial history is super important because we want to know what the courts below found important, what issues they decided on. And as you get more practiced at reading cases, and particularly Supreme Court cases, you'll find that they don't always decide all the issues, which can be very frustrating for the parties. It can be a very narrow decision that really wasn't all the issues that everybody felt really should have been decided in that case. Anyway, so then we have the facts, and you're just going to have the Gideon v. Wainwright, very straightforward facts, but I would say a couple of paragraphs of facts, and maybe one paragraph for a short case of facts. And here you're going to practice what you did in Chapter 3, which is choosing relevant facts. Facts that somebody who had no time to read this case would really want to know about this case. The parties, what exactly the facts are of the dispute, really relevant facts, and maybe a few explanatory facts. I think you should be over-inclusive and then begin to judge for yourself. If you've got 5 paragraphs of facts and it's longer than the case, that's a problem. But begin to use your own judgment, and also follow your intuition and instinct. I find that students have very good first common sense responses to what needs to be included. So don't second guess yourself. Include in there what you want, and be over inclusive, and let whoever reads the document, either me or your partner or another or somebody else, your supervising attorney, let them say, hey, that was a lot too many facts, that kind of thing. But being over inclusive is usually better. And hopefully that's for obvious reasons. Being under inclusive, not including important things, makes the case brief less usable, less useful for the person reading it. They can always skip things. Okay, so stating the issue. There can be multiple issues. So over the Gideon v. Wainwright case, there were 2 issues, and usually 2, maybe 3. And issues are usually stated as a question. Were somebody's rights infringed upon? Did somebody breach a contract? Did a particular activity amount to a breach of contract? State the issue as a question, but sometimes the question is about the law. Is this law unconstitutional? Does the party have standing to sue? So the issue could be simply law-based. It could be law and fact-based. And it's the question that we're trying to solve. It's the conflict that's before the court. The rules portion. Sorry. I just wanted to see if there was a separate slide for, sorry. The rules portion. Here, state the rules. What law, the code provision, probably in most cases that you're going to handle in this course and in this textbook, maybe 4 rules max. Typically, they don't pick cases that have many rules. You're going to get the Constitution in Gideon v. Wainwright. You're going to get the 6th Amendment, the 14th Amendment, in a couple of cases. And those, you're just spelling out what rules apply. Analysis or reasoning. This is a tricky part. So this is the most difficult to teach and to begin to do for students, but it's totally doable. So here for analysis or reasoning, you want to combine the facts and the rules and see if there's an answer to the issue. And I promise you, you probably do this already in your personal life when you're coming to a conclusion, when you're analyzing a situation, when you're deciding whether to make a particular move, whether it's a new job or take a course. You look at all the facts. So here you want to look at the status of Gideon, the states, and you want to say, well, just look at the analysis in Gideon v. Wainwright. Typically, you're going to use some very frequently used tactic in legal analysis. You're going to compare and contrast. You're going to say, the facts of Gideon are very similar to this case, where the court held that. You've now combined facts, law, with respect to the issue. And what does that mean to you? What does that mean to the court? What does that mean to this case brief, that the facts of Gideon are very similar to a particular case? Well, it means that if those facts and that case's binding were presented to another court, because of precedent and stare decisis, we would have to hold similar to the Betts case or whatever case had similar facts to Gideon. So that's comparing. You could also contrast. The facts of Gideon are very different than this other case. And so the court will probably not follow in that case. Well, the court will not hold the same way in that case. It won't be applicable. So in the analysis portion, you want to begin to predict, understand, and here in your case brief, it's super easy because you're really just talking about the court's analysis or the court's reasoning. But when you begin to look at your own analysis and beginning your own critical legal thinking, you're going to do the same, you're going to engage in the same practice that the judge is. You're going to compare and contrast, distinguish, explain that one argument was strong, one argument was weak, the facts were not here, the law was not here. But for the case brief, all you're doing is reading the court's analysis and reasoning and reciting it using facts and law, because that's what the court will have done. And then you're going to state the holding. But for the holding, I would like you to practice doing more than saying the court found for Gideon, or the court upheld the lower court's decision. Add one more sentence saying, finding, Gideon, the Sixth Amendment gave Gideon the right to counsel, the court held for Gideon. Okay, so let's keep moving on. Each component is a separate section with a labeled heading. Make your brief pretty. The reader is assaulted by a page full of text. Break up those paragraphs. Use headings. There are plenty of examples of case briefs in your book. Google them. But if you Google a case brief, that's one from the book, that's a case from the book, do not cut and paste. Do it yourself. I do check that. I do, if the brief looks too well written, I copy and paste it and look at it. And that doesn't help you. Just practice it. You're going to do fine. The idea is to practice and get better. If you're improving over the semester, that's what I really want to see. This is a class, unlike learning law, we're practicing a skill here. It's really a skills class. And so I think you want to practice it because you want to feel that you did the work necessary when you go out there and look for a job, no matter what it is, that you did the work necessary to get a little bit better at legal writing. And nobody's in the workplace is going to expect you to be an expert. But having done the practice, you'll be proud of yourself and it will show in your work and your work product at work. And you'll be appreciated, which means more money. So that's the most important thing. So redundancy is to be expected. Sometimes you have to repeat the facts. Sometimes the judicial history gets repeated, so don't worry about that. A little bit more detail about the analysis portion of the case brief. Yeah, I think I kind of said this. You make sure you're looking at, it is possible that during the analysis portion, you will pull in facts that, if a fact occurs to you in the analysis portion that you have not included in your facts section, you may want to add it in. So what you may find is you write the analysis, you're reading the case again, you're reciting what the court's reasoning was in the court's analysis. You may have to go back and edit and say, I need to add that fact, I left it out. You're comparing the facts of your case with the facts of the other cases that the court opinion is relying on. You're looking for similarities and differences. Compare and contrast. You're distinguishing. And also looking for gaps. So this is something when you feel the white noise and you're like, nobody said anything about this, but this is really important. Write that down and include that. It's not your own opinion. If it's coming from an analytical place, write that down. But really in general, for your paralegal program and your other classes, when you feel like more facts are needed or you feel like you would need to know more, write that down. That's good analytical thinking. You're evaluating. That's very good. So your book gives you the components of a case brief. When you're doing a legal research project or you're writing a case brief, put the components down and then plug it in. Write each section at a time, or start with the conclusion and go backwards. There is just the order that works for your brain. Case briefs are frequently part of larger projects, and so it's a good skill to have. So just in general, for your case brief and other legal writing, chronological is really useful, starting with facts that happened earliest and moving on. By court, starting with the lower court and moving up to the appellate court and then the final court, either the Supreme Court or the state court. Write one section at a time, but you don't have to start at section 1. You can. Sometimes people want to attack the analysis because they already have the facts in their head. When you use quotes or you use large portions of text that are from the case, make sure you're quoting them and citing them. Tell me the page number. Your case brief should not just be a whole bunch of quotes from the case. I need you to get to the next level, which is, yeah, I know you read it, and then summarize it. So that's a skill you're practicing, summarizing what somebody else said, finding and evaluating what's important about what the court said. Maybe this slide is a little self-explanatory. So just in general, legal research projects, and you will do I think it's a good chapter because it approaches very broadly any kind of project that's law related that may seem overwhelming. And I do think chapter 4 gives you a good strategy for approaching that. Always continue to go back and ask and read what you were asked to do. So sometimes I find that students do and then forget to reread the question. They may have in their mind or they're on a roll of how they want to do something, but continue to read the question and make sure you've answered the question or done the direction. You've completed the direction that you've been set to complete. That's always good advice. Edit. We're going to talk more about grammar in the next couple of weeks. Check your grammar. Voice problems. This refers to don't be argumentative in a document that's asking you to be neutral or predictive. So a case brief is very neutral. You're not arguing. You're not trying to convince anybody of anything. That's the voice or tone. So your tone must be neutral for a document that asks you to be neutral. Your tone must be persuasive when you're putting forth an argument. And then consistency and effectiveness, you want to use, you want to be using the same language consistently throughout the document. And effectiveness, don't write too much, don't write too little. Get the point across. In your editing, you may find that you need to add one more sentence. Typically, it just depends. Some students, writing is easy. For some students, challenge yourself. Say, could I write one more sentence that would explain this more? This course is for you to, what's the word? It's yours to use. You can go through this course and just answer the questions, but I challenge you to do more than that, because the number one piece of feedback I get from Orange County lawyers is that paralegals do not know how to write, and you can write. This is a chance to practice it, and you're going to get the tools that then you're going to carry forward throughout the rest of your legal assistant, paralegal career, compliance, whatever you're going to do with this certificate. These are tools for you to take with you, to revisit. Writing is a skill that develops over time. And you guys can do it. It just takes practice for everybody. It's not easy. It's just something you have to practice at, and maybe find that point of discomfort, as in yoga, and breathe into that space when you're holding a pose that really not hurts, but is challenging. Breathe into that space and take a look at it and make note of it, but not the whole course. The whole course cannot be one uncomfortable yoga pose. Then you need to come see me, and we'll find out how we can make it fun for you, because you are expressing yourself. It's just like talking. You're just putting it down on paper. And my students know how to talk. Okay. Blue Book. This week, I'm starting to assign citation practice questions. So in your module, you're going to be doing things from the appendix that have you looking at the Blue Book and understanding citation, the special way that law and lawyers refer to legal document, to any document, to websites, to a non-legal document, to a journal, to a newspaper, to a document contained in a website, to a quote. So for quotations, if you want to make a quote in a document, a case brief or a memo that's 50 words or more, it has to be indented. You're going to use quotation marks. All other punctuation marks are going to be placed outside the quotation marks. Oh, that's the last slide. And this is Rule 5. Look in Appendix C, which is an abbreviation of the Blue Book, which is the book of quotations used in law. And we're going to learn some of these rules. And it's how legal writers refer and support the things they say. Because in law, nobody wants to say something new. Sometimes you do. But mostly you want to rely on the support of others for what you're saying. And it's okay if you get stuff from other places. Just refer to it. That's so common in law. We love that. Ooh, they found that someplace else. That's so smart. They did some research. That's so cool. Just cite to it and refer to it, and don't plagiarize, and don't cut and paste. But if you do cut and paste, make it a quotation. Indent it, follow Blue Book. Impress me. If you cut and paste and you don't do that, we have to give you a 0. But yeah, so we're going to start learning the Blue Book, and it's going to be fun. The Blue Book is the Harvard created rule book for legal citation. As in other disciplines, there are specific ways that you make reference to authors that you rely upon, and the Blue Book is the one we use in law. Okay, thank you. And that is the end of chapter 4.